Not that actually you are biased. Let's distinguish the two. Not that you have demonstrated actual bias, but is there a likelihood of bias on your part under the circumstances? That's the point I was making, and the point I'm emphasizing, my lord. And this is what is envisaged under Article 28, when the Constitution talks about an impartial judge or court. It's about perception. That's the point I was emphasizing, my lord. And that cannot be determined by dishonorable court, because that's what the state was seeking, that you pronounce yourself on this matter, that whether there will be a likelihood of bias or not. It's not up to you, my lord, now to sit in your own matter. No. So, my lord, it's our prayer that you put all these matters into consideration and forward the matter to the Constitutional Court for reference. The issue as to whether this court has received, or actually the state has received, a copy of the complaint or not, has been succinctly addressed and answered by Counsel Kalibala. But I'll add one thing, my lord. So on record, my lord, in the course of the hearing of this matter, when the matter was being raised by A1 himself, attempts were made to supply with a copy of that complaint. The accused person, Dr. Besigye, volunteered to submit his own copy. And the court said no. The court declined and said, no, please retain your copy. There are mechanisms court will use to get its own copy. The state was interested in it, it was available, but they never expressed interest in it. So we retained the copy. But the fact is, my lord, what is not in dispute is that there is a complaint before the Judicial Service Commission. Yes, Judicial Service Commission. It's not in dispute. And indeed, from the record, court indicated that that matter is in existence. The court is aware of the existence of it. It's no longer in it's not in dispute at all. Finally, my lord, the option is talking about we have to file a substantive petition. Cannot be used as a bar for this court to invoke its powers to refer this question to the Constitutional Court. In the wisdom of the CA delegates who promulgated the Constitution under Article 137, these options were considered to be necessary to be enshrined in the Constitution. So all these imperatives were put into consideration when they were promulgating the Constitution. Under which circumstances do you invoke which particular provision? So in this particular case, Clause 5 of Article 137 is the most appropriate when a matter has arisen in the course of the proceedings. What do? You seek for an adjournment of the petition? No. The reasonable thing to do under those circumstances is to move the trial judge to forward that question for consideration by the Constitutional Court, which we are doing. So we reiterate our prayer, my lord.